The And a huge thanks to all of you who took time out to join today. And more importantly, our special thanks to our panelists today, uh, Parul and my namesake, Mr. Gagan Gandhi. Uh, Thanks, Parul, for taking the time out and taking this session. Uh, as you would know that we have received a sizable number of questions and we'll try and address as many as possible today. And many of you would also have questions. I would urge you to either put your questions in the chat box or raise your hand so as to maintain the uh, a free flow of discussion. So my humble request would be that please raise your hand before asking question, and so that we can answer them in a more logical manner. Um, so Parul, without wasting much time, the first question which we have today is someone who is having a shop, but his tenant is not vacating it. We do not know which state it is, but
Okay.
if you can throw a general light on that, that would be really helpful.
See, first of all, we need to understand that how long the tenancy had been. If it is for a very long time, then first of all, you need to serve him a legal notice before evicting any person. You cannot evict him just like that. First of all, you need to serve him a legal notice. And in that legal notice, you have to mention that you need this shop for yourself or for that he's not paying the rent on time or whatever the reason is. So after sending him this legal notice, you have to give that person, that tenant, a 30 days time. 30 days, after that 30 days time, if still he's not ready to evict the shop, then you have to file a suit of eviction, and in any of the civil court you have to file the eviction suit, and then only you can get the shop evicted from that tenant.
Thanks, Parul. So the procedure is fairly simple, but that you'll have to take some steps. And
Yes.
obviously, if still doesn't work, then obviously one can always approach court and get the
Yes.
necessary direction. Now, the next question seems to be relating to a family issue where someone is saying that he has not visited his hometown for about 3 decades and he might be entitled to a share in property which his brother is not cooperating. So, what can be done in such cases?
See, first of all, whether you have been to your native place for a long time or no, it doesn't make any difference. If you have a share in that property, that is, if you have that ancestral property, that means since birth, you have a right in your property. Okay. So, whoever is the, like, you have the right on your ancestral property. So, first of all, you have to see whether it is an ancestral property or whether it is a self acquired property of your brother. Okay, so if it is an ancestral property, you will get a right or you have a right on that property. So no one can take away that right from you. And if you have not visited that place for a long time, then you have to obviously go there. You have to be there to make them understand that you also have that right. And still, if they don't give you the property, then you have to file a suit for partition because you also have the right. So you can file a partition suit to get your right.
Thanks. But I think, would it have any bearing depending on the religion of the people, as in if
Yes.
they are
Yes. If
okay?
like this, I'm talking about, see, partition suit can be filed by anyone. Okay. So, but if you are a Hindu, then you have to go under the Hindu Succession Act. And other religions also have their own succession rules. But this, I'm talking about Hindu Succession Act, and the partition suit can be filed by anyone.
Okay. I hope the question has been adequately answered.
Yeah.
Now, the next question we have is that someone with physical disability has been denied his share in the property, are there any more benefit or more remedies available to such person, or he will have to go by the usual route?
See, first of all, no one can be disabled from, or no one can take away the property. Either you are a disabled person, because, but first of all, I will make this clear that now the property is not a fundamental right of a person. It is your legal right. Okay. Initially, it was a fundamental right under Article 19(1)(f), and after the 44th Amendment, it has been made a constitutional right or your legal right under Article 300A. So now you have a legal right to acquire a property. But yes, there are certain norms under which a disability has to be checked. If a person is mentally disabled, and we know that under the Contract Act, you cannot have a contract, or a property cannot be given and taken to a person who is of a mentally unsound. If he is a mentally unsound person, so the any person who is taking care of, that is guardian, or any person appointed by the court, can take care of the property. Okay. Now, if a disabled person is not being given his right in the property, then the court, he can go through the court, or his guardian can go through the court and get him the property. But he cannot be denied of the property, because he is also a human being, and he also has the right in the property.
Thanks, Parul. So essentially, there are no additional remedies. The existing remedies applies to
Yes,
a
because
person with disability.
yes, but yes, it is better to go through the court. Then that should be the legal procedure.
Great, thanks. Okay, the next question is that how a property, the ownership in property gets transferred in a family settlement.
See, first of all, the ownership of the property, transferring of the ownership of the property, first of all, can be through the family settlement. Okay. Like if we are brothers, sisters, like we are four members, brothers, sisters, and we can get the adjustment between ourselves, we can get a document made, we can get it stamped, and we can get the property distributed. But if you want to get it legally done, or the ownership has to be done legally, then the best possible way is to get the partition done from the court. Okay. And if you are in any village or near any tehsil, then you can apply to a tehsildar and get your property distributed, and then the ownership will be decided.
The next question is relating to registration. Now, the question here is that a document was executed in 1996. The
Okay.
question is that can it be registered now in 2023? And if yes, then what would be the value for stamp duty purposes?
See, first of all, any document above the 100 rupees, that can be registered. Okay. So, be it a document of 1996 or anything, it can be registered now. Okay. But yes, this court stamp duty of every state differs. Okay. So, you have to go to the court and check what is the stamp duty of that state.
Okay, but would it make a difference because the circle rate might have changed since 1996?
Yes,
So
it
the
has to
stamp
be.
duty,
It
so the
has to
stamp
be
duty would,
according to me, it will be of the current scenario. Okay.
okay, regardless of the value at which the contract was executed in 1996.
Yes.
Okay.
Because at that time it might be of 2 rupees or 3 rupees, but now that may not be of any value.
Okay. Okay. We have another interesting question. A daughter has lost her father, and apparently she has been entitled to some of the movable properties of which she does not have access to, like bank account, FDs, etc. So she wants to understand how can she get custody of these movable assets or know details about these movable assets.
Okay, so first of all, if she is the only child, or if there is, like, if she has brothers and sisters also, she has to get a legal hire certificate. Okay, first of all, she has to get that legal hire certificate, and through that legal hire certificate, she can deposit this legal hire certificate in the bank. From bank, the bank gives those bank accounts, bank details, and everything to only those person who are the legal hires of that deceased person. So first of all, she has to show that she is the only legal hire of that deceased person. For that, she has to get that legal hire certificate from the court. And usually, in like if you talk about Noida, the DM only grants this legal hire certificate. Okay, so you have to give your Aadhaar card and your deceased person details and everything. Then only you get this legal hire certificate that you can deposit in the bank, and through bank you get those details of your bank account and everything.
Parul, in my experience, what I've noticed is the challenges which come across in such cases is that normally brother or the other family members don't really cooperate. So they don't even inform that what all bank accounts are there. So even if you get all those certificates and all, you don't know which bank to go to. So
Yes.
how do one deals with such a situation?
See, first of all, in that case, you should go to the court to get every detail of your deceased person. Like if your father is no more, then you have to go to court. Regarding that, court will ask the brothers and sisters that all the details of the deceased person, the property details, the bank account details, or whatever the locker details are there, they should be given to the, they should be disclosed in front of the court. Then she can get that done. That means it should be legally done through the court only.
Yeah, thanks. We now have the benefit of another panelist, Mr. Gagan Gandhi. Welcome, Mr. Gandhi. Thank you for joining. So let me straight away ask you a question now. The question is like this. The question is like this: that how do one establish ownership of a property which is located in an area where documents are not registered?
So ownership you can either establish through possession, that you have a possession, and if it is 12 years, more than 12 years, then you can take plea of an adverse possession as a shield, as a sword, which earlier was taken only as a shield. Second thing, like you're talking about unauthorized colonies, so you, as you rightly said, that there are no documents which get registered and there is no absolute ownership actually, or the properties which belong to public agencies like BDA or like slum. So then only by way of GPA, general power of attorney, that you exchange the property or the property changes hands. I hope I have answered that.
Well, I also, because I got these questions and will ask the audience if this question was. Okay, so now this question seems to be relating more on matrimonial issue than the property law, but since the moot point here is the property, so let me ask this question as well. So the question is that if the property is not in the name of the boy, can the wife claim her right over the property in case of divorce?
Is it to me?
So, any one of you can answer.
Okay. If the property is not in the name of the boy, then the wife can claim right to stay in the property. He cannot claim right to ownership in the property. And that is as per the recent 2019-2020 judgment, that right to matrimonial house, where the Supreme Court has established that the wife is entitled to a matrimonial home where she was staying after marriage. And in case the property belongs to the relatives of the husband, then she is entitled to alternate accommodation, which is equivalent to where she was actually staying as far as the standard of living is concerned.
But what if the divorce has been granted? Can she demand some right over such property?
No. So she is linked through marriage. So once the marriage is annulled, then there is no question of her getting linked to the family of the boy. So our first point of contact is through the boy only.
Okay. Okay. There is one specific question relating to BMC, so Brihan Mumbai Corporation, Municipal Corporation. If you would have any idea about that, then I can ask that question.
I do not know whether my co-panelist.
No, I also don't have any idea about Bombay Municipal Corporation. So.
But still, you can actually raise the question if we are able to answer it.
Okay, the question is that what is the valid defense under Section 351 of BMC notice if the construction of chawl room increased without permission? So looks like a question relating to increase in FSI area.
Yeah, FAR, right.
Without seeking the necessary approval.
So
what would be the situation under Delhi?
Yeah, exactly. So I would have answered based on Delhi.
So if we talk about Delhi, then a person cannot, or the builder cannot increase the area of any of the property, be it a flat or be it, I don't know about the chawl or that place. But if we talk about Delhi, a person, the property dealer, the builder, sorry, he cannot increase the area without the consent of the purchaser. And if that has to be increased, that has to be given in your when you have those agreements that only this percent can be increased, and beyond that it can't be increased without the permission of the buyer. So that is I have an idea about the Noida or Delhi.
So
you want to add on something?
One plausible defense which we take in Delhi in case of DMC is that there is a cutoff date. So we have a Delhi Special Protection Act, which gives protection to properties which have been constructed before a certain cutoff date, which is 2006 in Delhi. I don't know the exact date. So you can say that this construction was actually prior to that date, and then you have to prove through electricity connection, through renovation bills, through carpenter, electrician, plumbing, etc., that yes, you constructed this property before that cutoff date.
Okay. We have a question from one of our audience, Swati Setia. Swati ji, you can ask your question. Swati ji? Okay, I'll just read out her question. Her question is that can we sell and purchase property in Delhi which is leasehold till date, and does it need to be freehold property? So basically her question is that can leasehold properties be bought and sold?
Sorry, I don't have any idea about it. Sir, if you can answer it.
Yeah, so leasehold properties you cannot actually sell, because in that case the lesser is either DDA or the slum, JJ Jhopadi slum. So what you actually you give the possessory rights. Like if I'm lessee in that property, so I can at best give my leasehold rights to somebody else, and that too I would not be getting it registered, because actually the property belongs to somebody else, not to me. So what I can transfer only what I have. Since I do not have that property in my name, so I cannot transfer it, or I cannot enter into a sale agreement.
Gagan, I think the question here probably refers to the properties which are leasehold with the President of India. So like until the conveyance was allowed and freehold was permitted, practically every property was a leasehold property in India. And it's only in early 90s, this freehold was permitted, and people started making payment for conversion charges, and the leasehold properties were converted into freehold.
Right.
I think they might be having one of such properties where the freehold conversion has still not taken place.
Right. So you are right. Actually, in that case, what is happening? Sale and purchase is taking place. But that sale and purchase is hit by the Suraj Lamb's judgment of 2003 or 2011, sorry, which actually earlier you had GPA. It was called actually agreement to sell and GPA sale and purchase, which after Suraj Lamb became actually null and void. So you have to get agreement to sell registered, but that will not give you, that does not give you right in the property. So at best, you can get your specific performance enforced through that agreement to sell. So there is actually a caveat with respect to that sale and purchase.
Okay. We had a question from Mr. Hitesh Kumar Sharma. Is it still there? Yes. Hitesh, you can ask your question. If you can see the chat box, probably you'll see his question. Question is, kindly tell me about lease. A private person can take lease in any property. Is it legal? Okay, anyways, let me ask you this question. Every lawyer is getting an office in a basement in Delhi. Is it legally permissible or not?
Yes, it is very much permissible. Only if your basement is actually constructed after the stilt parking came into being. So then you could use only basement for the purpose of storage and not for the purpose of commercial use, because that is free from FAR. So if you want to get it included in FAR, you have to pay that much amount actually. But most of the basements where lawyers are working, these are constructed without stilt parking.
So they are fine. They
Yes.
can be used.
Yes, absolutely.
Okay. And isn't the master plan says that you need to be owner of the property and only 25% of that area can be used for a professional by like a chartered accountant or a doctor or a lawyer or an architect?
Yes. So actually I will show 25% usage only.
Of the total property?
Yes, yeah, absolutely.
But only if you are the owner of the remaining 75% as well.
No, I take it on lease actually. We do not sell it. Most of them have taken on lease. I think we will not be able to afford buying the basements.
Yeah, so basically then as per the master plan, is it all right to move into legally, not the practical aspect?
Sir, I can answer more answer actually, provided this is not getting recorded. my only concern is that it is getting recorded.
It is getting recorded. Anyways, so I guess Fatima had a question. Okay. Okay, a very general question someone has asked, that what is the difference between a lease agreement and leave-in license agreement?
Ma'am, you would like to answer or should I answer?
Yes, sir, please go ahead.
Yeah, so in lease agreement, you actually get right in the property. Whereas in leave-in license agreement, you do not get right in the property, which means you are only having the lock-in keys with the owner. You only get permission to use that property, which is usually the case in case of malls or in case of restaurants, hotels. So where you get a shop, like you will find saloons or you will find stationery shops selling expensive pens. So they are actually on leave and license basis. Whereas if you actually get the possessory rights in the property, then actually it is lease. So one more difference is that lease is heritable and leave and license is not inheritable. So my son or my daughter will not be able to inherit if I have a leave and license. But if I have a lease right, then my son and daughter will be entitled for that.
Okay, I've got one more question. It says that this girl, after marriage, her father died intestate, and the brother and mother sold the property without sharing the information with the daughter. So, what remedy does she have now?
She can seek partition and possession in the property.
She can now
The
file a
property has
suit.
been disposed of.
No, so still she can file a suit, and she
Yes.
can get the money, whatever the mother and brother has got. She can claim that money.
Because legally she's entitled to 1/3 share after the demise of her father. Second thing is that if there is a provision in IPC also, she can invoke that if you want to go to that extent, that this
Criminal breach
property,
of trust.
absolutely.
Yes.
Okay.
Along with the mischief, actually.
Along with?
Along with
Yes.
mischief. 423 and 424.
Okay. Ajay Jha ji has a question. Go ahead, Ajay ji. Ask.
Yeah, hi. So actually, as you said, actually, she can file a suit and she can claim the money from brother and mother, whatever. So actually, she will claim the money from whom? Purchaser or brother?
No, from brother and sister, or brother and mother.
Okay.
Because her right is against them. Purchaser is alien to her.
Okay.
Well, purchaser will be performer party only. He will claim that I am a bona fide purchaser. I do not know who all have rights in the property. So it is actually duty of the brother and the mother that they should have given the 1/3 share because he died intestate.
And what if the purchaser was aware of this fact, but he joined hands, and can the registration be cancelled?
No, it is difficult to get the registration cancelled because the purchaser will never admit to this fact that I was aware that she also.
Okay. If there are evidences on record, something to suggest that he was aware of the fact, and
then he can be
maybe never
made a party to it. He can also be made a party. But then, as sir said, that the girl has a right only against the mother and the brother, not against that purchaser.
Okay. We have another question from Mr. Ritesh Jain. Ritesh ji, please go ahead. Yeah, Ritesh ji, please ask your question. Okay. Ritesh ji, are you asking the question? Okay, now we've got one more question. They want to know whether RERA applies to builder floors, or does it apply only to big apartments?
There is a limit which has been assigned in the RERA Act. So if you are actually above that limit in terms of the business or revenue, then you will come under the ambit of RERA. If you do not meet that limit, then you will not come under the ambit of RERA.
Okay. Okay, we've got another question. Someone bought a plot from a society, but the possession was not taken, as Noida authority has not handed over the possession so far. What can be done in such a case?
You can.
Yes, sir. So please go ahead.
You can actually initiate consumer complaint against the society to seek possession. if the entire payment has been made to the society. Secondly, you can approach RERA, as you mentioned before, to invoke that why my position is being delayed, and seek a refund or seek on interest on the money which you have paid to the society till the time you actually get possession of the society.
Okay. Okay. Riteshi, you can ask your question if you want. Madhura, I think Riteshi is facing some issue in getting himself unmuted. If you can unmute him.
Yeah, actually, sir, anyone can unmute. I'll just check if there's an issue.
Okay. In the meanwhile, Kritika, you can ask your question.
Ma'am, would you like to take this?
Which question? I'm not able to open the chat. I don't know why.
Okay, so I'll read it out for you. If a person acquires the government-owned land for a considerable period of time, will they be entitled to the property? That is, will they have any right over the property? It's basically sort of encroachment on a government land.
So one cannot encroach on a government land, first of all. And if he has acquired the land, is it a legally acquired land? Is it given by the government on lease?
No, it appears from the question that the possession was there for a fairly long time.
Okay.
So the question seems to be that if the possession has been there for over a fairly long time, can they claim any kind of ownership over the plot?
No, if it is a government land, you cannot claim it as an owner of that land. I think so. What do you say, sir? Sadan sir?
Yeah, so first of all, if it's a government land, then definitely you will never be the owner. So you would have only right to enjoy that land. So what I think she is asking is A, encroachment. Encroachment definitely cannot be legalized, whatever span it may be. B, it could be adverse possession. So adverse possession against government is for 30 years. So if the government does not take any action for 30 years, then you can say that, yes, I am the owner of the piece of land because I am enjoying that piece of land for last 30 years. Now, if the land gets acquired and notification gets issued under the Land Acquisition Act and Section 4, then the government will give you compensation for acquiring that piece of land for any project, maybe it's metro or any other project. So then anyway, you will lose the possession of the piece of land which you had for so many years. And government can do so at any point of time. So land acquisition, you cannot say that since I am being in the possession or I am the owner, I'm having possessory rights for so long, so you can't do that. The governments have done in the past and they can do in the future also.
That is why it has been removed from fundamental right. That is why it was removed from fundamental right and made a legal right.
Absolutely. So 300A, she's talking about 300A of the Constitution. Okay. So now you only have the right to enjoy the property. Now you can't claim ownership over the property.
So you are not audible?
Gagan sir, I think...
Yeah, I think he has lost audio. Mr. Paresh Baroth, are you having a question? Do you want to speak? Please ask your question.
Yeah, मैम मेरे पास मैं एक मैटर में सोल आर्बिट्रेटर अपॉइंट हुआ हूँ जिसमें फैमिली प्रॉपर्टी डिस्प्यूट है जिसमें 2 ब्रदर थे 2 सिस्टर थे दोनों ब्रदर ने इन ईयर 1996 थ्रू कोर्ट सेटलमेंट पूरी जो लैंड थी वो दोनों सिस्टर को दे दी डिक्री हो गई उसकी उस टाइम डॉटर ऑफ द वन ऑफ द ब्रदर 18 प्लस ईयर की थी अब वो 2022 में क्लेम लेके आई है कि मैं उस टाइम भी 18 प्लस की थी मेरी कंसेंट नहीं ली गई है एंड क्लेम अमाउंट इज अबाउट 500 crores तो इन लोगों ने जॉइंटली एक एग्रीमेंट करके मुझे एज अ आर्बिट्रेटर अपॉइंट किया है एज अ सोल आर्बिट्रेटर तो क्या उस लड़की का उस बिटिया का हक बनता है या नहीं?
Yeah, so if I got your question correct, it was the property which belonged to whom, sir?
Yeah, grandparents of that brother.
Grandparents.
Yeah.
Okay. So 2 brothers and 2 sisters, they alienated the property in 2002.
1996.
1996. And the girl at that time was minor.
No. She was 18 plus.
When the property was alienated.
Yeah.
Okay. So what is the grievance?
The sister was 18 plus.
नहीं. जो दोनों भाई ने अपनी प्रॉपर्टी दोनों सिस्टरों को दे दी, उसमें से एक भाई की जो डॉटर थी वो उस टाइम सेटलमेंट के टाइम 18 प्लस थी, वो अभी 2022 में क्लेम लेके आई है कि मैं 18 प्लस की थी लेकिन वो सेटलमेंट में मैं हिस्सा ही नहीं थी, ना मेरा कोई कंसेंट था, तो इस प्रॉपर्टी जो है उसमें मेरा हिस्सा भी है.
So in this case, brother, in this case, the father of the girl who is claiming right now was alive.
हाँ, अभी जिंदा है.
Right? And that time also he was alive.
Yeah.
So property could not have devolved on the daughter at that point of time.
Yeah.
So property, she whether her consent was taken or not is immaterial. Because she didn't have a right at that point of time in 96 when the property was alienated. So this claim is misplaced.
लेकिन सर
whether
उसकी एज 18 प्लस थी.
Maybe.
अच्छा.
But property should devolve upon her by virtue of any instrument. When the father is alive and the property would have devolved upon her father by grandparents.
Yeah.
So now the father is in a position to take decision. So he took decision to alienate the property.
Okay, fine. Now understand.
Until unless it's an HUF property.
Yeah.
If it's an HUF property, then this claim is legitimate.
Okay.
Is it an HUF property?
No. It is a grandparents' ancestor property.
Okay.
Then the question does not arise.
And the girl cannot claim.
In short, at the time of settlement, उनके father को पूरे rights थे.
Yes, absolutely.
Thank you very much.
I think Ramesh has some questions. Ramesh, go ahead and ask.
Good afternoon, sir. All panelists, sir. Ramesh Kumar speaking. Am I audible, sir?
Yes, sir.
Sir, my simple question is pertaining to Noida and Greater Noida Authority, sir. A very peculiar kind of thing is happening. Generally, the builders are allotted the land by for example, Greater Noida Authority. And they have started construction for the apartments and they have been selling those apartments to the buyers. But even after 8-9 years, they have not paid the land cost to the Noida Authority. So, what's happening? The Greater Noida Authority, in many cases, I have read the news. So, what they are doing, if the builder has not paid the dues of the land to the authorities, so they are appointing the receiver to liquidate that property to recover that amount. And in that case, sir, if some of the purchasers, home buyers are given the possession, so how they will be able to protect their rights? That's my main question. If you could have been able to understand my question, sir.
Ma'am, do you want to address since it pertains to Noida?
No, it's okay. You can go ahead.
You got my point, ma'am?
You have to actually let me go back again. You are saying the Greater Noida is allotting plots to the builders, right?
I'll repeat, sir. I'm again repeating the questions for better understanding of the problem, sir.
Yeah.
So here in the Greater Noida Authority, what's a very peculiar kind of thing is happening almost with every builder and the home buyer, sir. Greater Noida Authority is allotting the land to the builder to construct the apartments, sir.
Right.
And the builder is supposed to pay the land cost to the Greater Noida Authority.
Right.
But then what they have been doing for 8, 9, 10 years, they have not been able to pay the land cost to the Greater Noida Authority.
Okay.
Simultaneously, what they have been doing, they have been constructing the apartments and selling the apartments to the home buyers, sir.
Okay, got it.
And sometimes what they do, they simply give the letter of possession to the home buyer, sir. And if the home buyer asks for the registration of the flat, then the Greater Noida Authority is not registering the flat because they claim that the builder is not having the title of the property.
Right. Absolutely. Perfect.
And the other phenomena which is happening, the builder is not able to get the occupancy or completion certificate from the authority. That is another reason. So in that case, sir, because the buyer has paid the money to the builder and the builder is keeping all these things secret and not disclosing it to the buyer, that they will not be able to register. And after having given the possession letter, when the home buyer complains to the builder or the Noida Authority or the RERA, the builder is not registering, so ultimately they come to know that the builder has not paid the dues and they do not hold the title. So there you will not be getting the registration. So that is a very common kind of problem, and it's a type of strange thing happening. So what remedy you perceive, sir, with your all enlightened knowledge, sir?
So first of all, you are not privy to the contract between the authority and the builder, right?
Builder, suppose I am the privy to the builder. I'm having the
your contract is with the builder.
Yes, sir.
This is not a tri-party contract where you have an authority, builder, and the home buyer.
No, it's a bipartite contract, sir.
Bipartite contract. Right?
Yes, sir.
So you cannot agitate that issue with the authority.
Okay.
First of all, because of the privity of contract. So the possession letter which the builder is giving to you is actually without authority. That means.
Yes.
Because first I should have the ownership, then only I can transfer it to you.
Yes.
So that is why they are giving only possessory rights to you. They are not giving, they can't get the registration done for you.
Mm-hmm.
But that is not what you paid for. Ultimately, you want registration. Actually, you want to be the owner of that apartment.
Definitely, sir.
So A, you can have the police complaint against the builder. B, you can check the occupancy certificate at the time of the letter of possession. That, or when you are actually booking the flat, you can seek those documents, that whether you are actually the owner or not. But that's preventive. But once you have already entered into transaction, you can't have that preventive measure. Now the only thing is to actually get registration done. So second option is that you can take them to NCLT. That I paid my money, I want my money back. Simply, I don't want the flat, because flat you will never be able to give me. Since you do not have paid to land cost to the authority will not give you ownership. You will not have ownership. I will not be able to register my flat. So you pay my money back with the interest. Simple. So these are the
just with the permission, sir, if the home buyer wishes to go to the NCLT for resolution of the grievance, then to the best of my knowledge, you can further add to my knowledge, sir. The minimum 100 financial creditors are required to start the insolvency process as per the amended law, latest amended law.
No, you are the creditor, financial creditor in this case to the builder.
Sir, all those who are the home buyers, they are the financial creditors only, sir.
Yes, absolutely.
So if the financial creditor files a complaint to the NCLT, in that case, sir, as per the latest amendment, to the best of my knowledge, if you may add to my knowledge, sir, the minimum 100 financial creditors are required to initiate the insolvency proposal and to liquidate.
So in that situation, you are left with 3 remedies. One is the FIR, second is the consumer complaint, third is RERA. So consumer complaint.
And with your permission, excuse me, sir. With your permission, if you suggest that there should be a complaint to the police, so what offense you feel it appears the builder has done?
The offense is forgery. You don't have the right. How can you transfer it to somebody else? The builder-buyer agreement itself is a forgery. First, I should have a right. Then only I can enter into any agreement further.
Okay, that's very nice, sir.
Yeah.
So will it fall into the
forgery with the intention of cheating?
Cheating will also happen.
Yes, forgery with the intention of cheating will include cheating.
Okay.
Because this is common practice in Noida and Greater Noida that has been seen from past many years, that the builders are doing this the same practice.
Yeah. And that's why the scams are not coming to halt. That's a major issue, man.
And that is why the complaints under RERA is they are pending like anything. They have so many complaints in RERA, and the matters are pending from past so many years.
Yeah.
And first,
Very
if you
good.
get the FIR registered, then you actually claim for PMLA also. You can invoke PMLA also. Why? Because he's diverting the funds.
Yeah.
He took money for the construction of that, right? And if he has diverted that money to some other project or to some other business venture, then he will be liable for PMLA also. Or if you think your money is being siphoned off to foreign country also.
So that's I being the individual buyer may not be having that much evidence, but then ultimately it is a process of investigation, matter of investigation only, sir.
Yes.
So once the complaint is lodged with the police, they can go ahead for the investigation and find the ultimately what's the offense. Sir, just to elaborate in one case, sir, one customer just came to me and his case was very extensive. The one he booked the flat in, it's very interesting. You may just think how and what action may lie and how the builders are able to commit crimes. The builder, so one builder was in name of A for A, and he just got the money and booked the flat for one home buyer. And then after 2-3 years, the another builder took over the virtual charge of that apartment, and then he's without any court orders, without any apartment owners association resolution, he offered that the whatever payment the earlier builder has received, he will agree to include those in the payments of the home buyer, and the further payments which the home buyer will give, he will also acknowledge. So earlier builder's payment was acknowledged by the new buyer, new builder, and the payments which were given by the home buyer to this new builder, so they were also acknowledged. And this new buyer B, after 2-3 years, filed one operational creditor filed a insolvency resolution against the builder B. First builder A, he did not have any insolvency issue. Secretly, he handed over the project to builder B, and then the builder B, after 2-3 years, having received more payments from the home buyers, through the, I would say, some have been some unholy nexus with the operational creditor, and he filed an insolvency suit in the NCLT, and then the insolvency resolution was passed against that builder, and the IRP was appointed, and one new what we call the resolution applicant was approved, and then sir new that resolution applicant, which ultimately took over the charge of the project after the liquidation proceeding, and then the NCLT, he assured that he will restructure the company, and then he will complete the project, and whatever the home buyers have paid that earlier money, he will acknowledge, and he will not escalate the prices, and will deliver the homes at the original price of booking, like that. So there is a secret nexus between all these type of builders. And sir, after 2-3 years that the resolution applicant did not start construction, and then he, with the builder B, who was pushed into the insolvency, some directors from that insolvent company with the new resolution applicant company, few directors from the insolvent company, and from few directors from the new insolvent this resolution applicant, they formed a new restructured company, and they started the project in the name of new structured company, and no information has been passed to the home buyers what they have been doing, why they did not have been constructing these apartments for the last so many years, and why this restructure has taken place, though that was not the proposal before the NCLT. So now what they are asking, the latest structured company, then they will pay them the remaining amount from the home buyers, and they again assuring the possession. The problem still remains. The land cost is not paid to Greater Noida Authority. What they they have created. In one of the case, they have filed the insolvency.
Rameshji, sorry to interrupt. Actually, we are running out of time. I guess
anyway,
you may take it
all your
offline,
privilege, sir. Yeah.
The Zoom will throw us out in another 2 3 minutes.
No issue, sir. No issue. Welcome, sir.
I think you can take this issue offline with.
Thank you for patient hearing, sir. Thank you, your patient hearing, sir. Thank you.
So I guess with this, we have come to the conclusion of today's Legal Aid Clinic. Thanks a lot, Parul. Thanks a lot, Gagan, my namesake. And thanks for taking the time out. I hope we have been able to address a sizable number of questions today. The participation has been very encouraging. And thanks a lot to all the participants who came and joined this Legal Aid Clinic. We wish to continue this practice in the months to come. Last month, we had this Legal Aid Clinic on matrimonial law. This month, we had it on property. And next month, again, we'll circulate amongst our members that what is it most sought after or most desired topic is. And then we'll probably take it up again. And we may request Parul and Gagan again in one of the ensuing meetings again to join you so that we can have the advantage of your experience. And
thank you, sir.
Thanks, Madhura. Thanks a lot. And thank you.
Thank you, sir.
Thank you, sir.
Thank you so much, sir. Thank you, everyone.
Thank you. Thank you, everyone. Bye. Have a good day.
Thank you, sir. Thank you, ma'am.